Let y'all get in before we start jamming. Peace, peace, peace. Today, I'm going to be talking about your private rights and the enforcement of your rights. Okay, and this is something that it took me a little while to kind of grasp when I first started learning all this information as well. And it also will explain um, why I'm always talking about the administrative process. Okay, the first thing, let me hit you with a few basic principles. Okay, there is a maxim of law in there's a maxim of law in the Black's Law Dictionary. You get in the back of Black's Law Dictionary, you get like an eighth edition, ninth edition, seventh edition, 10th edition, and you'll see in the back, you'll see these maxims of law. Okay, well, one of the maxims that you have to understand is that the spoken word flies out the window and the written word remains forever. And also from the 10 commercial maxims of law, for a matter to be resolved, it must be expressed. Okay, so letters are contracts. I want y'all to understand that. So when like an attorney, like say when you're going through a foreclosure, and the attorney sends you a letter, and he lets you know this is a debt collection. If you don't answer within the specified time, it's going to be presumed. It's a presumption that this debt is valid. It's going to be presumed that this debt is valid. All right, it's a presumption. It's an operational presumption. There's a presumption that the debt is valid. All right, now, I heard someone say one time there's no such thing as debt, there's only the presumption of debt, which, of course, it has to be true because there isn't any money and the banks didn't really loan you anything. So that's a true statement. When you get into the accounting of all this, you know, everything is based off of a presumption. And this is also the reason why when third party debt collectors, they don't have any inherent right to collect anything. And 70 to 80% of what they collect is solely off of summary judgments because an individual did not answer the letter. When they send you a letter, say you owe us this money, you got to answer within a certain amount of time. You don't answer, they just go right into court and judge didn't answer. Okay, it's a default judgment, and then they just get the money. Now you have a lien against you, and now somebody is taking money out of your check or something like that based off the fact that you did not show up to court. And that's like 70 to 80% of debt collectors. That's how they get off. It's a big money maker for them, and it's a shame because it shouldn't be. It should be the least money maker for them. As a matter of fact, when I used to help people with third-party debt collecting, that would be some of the easiest stuff I would do because off the bat, a third-party debt collector falls under the consumer protection laws under the 15 USC 1692G and the verification of debt. You need to know that verification means that they have to provide some sort of affidavit attesting to the fact that they are indeed a creditor and they are owed some sort of obligation to you. All right, but what I want you to understand is when you conduct an administrative process, what it is and what's happening is that you're creating a contract situation. All right, this is the reason why you send it certified mail, and this is also the reason why you have a notary send it. Now, when you do a administrative process, you never send it yourself. Now, you can send it yourself. I'm not going to say you can't. All right, but the preferred and most powerful way to send it is to have a witness send it, like a notary. That's a witness. Okay, the notary is only there to attest that something was mailed and what the contents of the correspondence were. She's not there to get into any legalities of what you're doing or anything like that. You don't involve her in none of that. All she's there to do is to witness that something got put in an envelope, you know what it was regarding, and it got mailed to a specified address. And she's the one going to do the mailing because she also has to be a witness that nothing got mailed back. Okay, this is why you always have a notary. If you look in creditors and their bonds at all those templates that they have on there, you'll see every last one of them are mailed from a notary. They're not mailed from you. All right. Now we are utilizing um, a doctrine called silence is acquiescence. You know, if you fail to respond, then you agree with the contents of the correspondence and you adopt them. All right. That's what's being utilized as well. But we're creating a contract. It's an agreement. I read this. It was one of the most powerful things I've ever read, and it was in a military manual where they were talking about civilians' lack of understanding of rights. Lack of understanding of rights. In the Constitution, we got probably about the major right that is protected in the Constitution that we possess is the right to contract unlimited. It ain't freedom of speech. It ain't possessing a gun, because all those things can be contracted away. You can actually waive all those rights through a contract. You can give them up by signing your name on a piece of paper and giving them up. So the most biggest and most important right that you have is a private right to contract unlimited. You have the capacity to contract unlimited, and that could be a blessing or a curse, because your ability to contract unlimited can be used against you. You also have to understand that there are verbal contracts, implied contracts, and written contracts. All right. You got to understand there are different types of contracts. You got to study contract. You ought to get a nice understanding of contract law. Do a little study on contract law. Probably wouldn't hurt you to get that. But understand that when you do your administrative process, those constitute contracts. You're creating an agreement of the parties. This this also means that you got to understand how the court system works, because a lot of people are under the mistaken impression that just because they sign an affidavit, then that is like truth. Like that's the truth, the whole truth, and nothing but the truth. Nothing could be further than the truth. Okay, or it constitutes some sort of facts. Okay, an unrebutted affidavit becomes fact in law. An unrebutted affidavit becomes fact in law. Because what? Silence is acquiescence. There's an agreement. Okay, so we are looking to get agreements. Okay, there has to be an agreement of the parties. You got to know in law what constitutes a fact. A fact in law is a stipulation. It's when both sides agree on the same thing. If I say the sky is purple and you agree that the sky is purple, we can both take that into court, and that is a fact because we both agreed on it. But if I say the sky is blue and you say the sky is purple, that's a material issue of fact. Then we have to go before a fact trier. Okay, a trier of facts. That is usually a judge sitting on a bench, what they call a bench trial, or a jury trial. Okay, there is an argument. Before you go to law, we have to establish what the facts are. This is the reason that you are doing an administrative process in the spirit of Matthew 5:25, where it says, agree with your adversary while you're on the way to court with him, lest he hand you over to the judge hand you over to the bailiff, and the bailiff cast you into prison. I tell you, you will not come out until you pay the very last penny. Farthing means penny. All right, so understand that. Understand that the administrative process is creating a contract situation that you can take into court. This is why it is so important that you document. Everything is about documentation. Okay, so the first step, okay, let's say you discharge in a debt. All right, well, you're going to do a notice of acceptance. You know, I've accepted this presentment, and look up the word definition of presentment, the commercial definition of it. Okay, not the presentment utilized in the Constitution. Presentment in commercial law means that someone is presenting something, a negotiable instrument for acceptance. So you've accepted that presentment. In return, you're utilizing your exemption. Your exemption is your closed account. Okay, your closed account is your social security number without dashes. A lot of you have probably been into this sometime, and you've noticed that people write acceptance for value at a 45-degree angle on paperwork. And you've always wondered, well, why do I have to write my social security number without dashes, or I'm writing it with dashes? When you write your social security number with dashes, that's an open credits. All right. But a closed account is closed for debits and credits, but remains open for adjustment and set off. Once again, you need to look up the definition of closed account. It's under accounts under a Black's Law Dictionary. Understand what a closed account is. So the social security number represents your exemption. It is the only number in the public that represents your straw man. It also represents all your property in the public. All right. So we're letting them know And this is why you can fill out a form 524 and send it in to the Social Security Administration. And people say, well, didn't I, rescind the Social Security number? You don't, accounts never go anywhere. When you close an account, all the Social Security Administration is going to tell you from that point is that you have to stop using it. And they're going to monitor you very closely to ensure that you're not using that Social Security number anymore, which is very difficult to do in today's society where everybody's requesting your Social Security number for almost each and everything. So understand that. Okay, understand. All right, that when you write your Social Security number without dashes, that represents a closed account. And when you write it with dashes, that represents an open account. So now we can also go and look at these little acceptance for value stamps, and you can work real closely. And somebody said, well, write your Social Security number with dashes. That's a person that doesn't know what they're doing. You don't write your Social Security number with dashes. All right, you write your Social Security number without dashes. All right. All right, want to make sure that we understand that. We got to make sure we got a good understanding of that. Okay. Your exemption, okay, it's called an exemption. What is an exemption? An exemption represents your promise of HGR 182 of June 5th, 1933, that the government would discharge all debts dollar for dollar. Okay, this is the secret that they don't want anybody to know, based off the fact that they took the gold out of circulation in 1933. Now, this really wasn't for private citizens. This was only for people in the public.